For us to have a justice that says precedent is more important than original intent is going to give a lot of people in this country heartburn, because what it says is our intellectual capabilities are better than what our original founding documents were, and so we're so much smarter as we've matured that they couldn't have been right. And that's dangerous territory for confidence in the court.
Senator Coburn, I think what I'm trying to say is that courts appropriately look to both keys to constitutional interpretation, that courts appropriately look to original intent, that courts appropriately look to precedent, and that it depends on the provision of the Constitution, it depends on the case, it depends on the issue, as to which one of those is most helpful, and that it's a pragmatic approach, looking case by case to try to figure that question out.
You've told this committee that you think that there is appropriate time to use foreign law. You told this committee that in your Solicitor General testimony in terms of answers to questions.
You said as Solicitor General, I advocated the use of foreign law in some circumstances, and I do just want to make clear that what I said in those questions.
Here's your quote. Exactly.
Was that because there are justices on the Supreme Court who believe in the use of foreign law in some circumstances, that I would think it was appropriate as an advocate to argue from foreign law or to cite foreign law in any circumstances.
Well, but that isn't what you said here.
Well, I think, Senator Coburn, with all respect, that if you look at the question and if you look at the answer, I was speaking in my role as an advocate, saying that the primary consideration of an advocate is to count to 5 and to try to do the best the advocate can to ensure that the position that the advocate is taking will prevail.
But it's not your position because some other justices are using foreign law. You have the authority to do that as well.
As an advocate, to the extent that I think that foreign law arguments will help the government's case, then I will use those foreign law arguments.
Let me read something to you. As it's obvious, I'm not a lawyer. Okay, it's pretty obvious. But Article 3, Section 2 says this: the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and the treaties made. Nowhere in our Constitution does it give the authority for any judge, Chief Justice of the Supreme Court, any jurist on the Supreme Court, or any other court, to reference foreign law in determining the interpretation of what our statutes or our Constitution will be. So this is an area where we have grasp, where our judicial majority, much like the Israeli judge, that we start reaching beyond the Constitution. You said it was all law. You said the determination will always be law. It's down to law, law, law. The earliest questions that you were asking in this hearing. Well, this is the founding document of what the law is. Nowhere that I can find in this writing or in these guys' writing says anything about using foreign law. So please explain to me why it's okay sometime to use foreign law to interpret our Constitution, our statutes, and our treaties.
Senator Coburn, I think for the most part I wouldn't try to convince you of that, because I don't think that foreign law is appropriate as precedent or as an independent basis of support in the vast majority of legal questions.
It takes me to the next thing that you said that I have heartburn with. I have great difficulty in the ability to take off my advocate hat and put on my judge's hat. And my question to you is, I would have the same problem. I will tell you, how are you going to take off your political hat? What are the processes with which Elena Kagan is going to take off this advocacy of a liberal position in this country as she becomes a justice of the Supreme Court, so that that advocacy hat is gone and only the judgment hat is left? How are you going to do that? You've already admitted you have trouble doing that now, just from a Solicitor General standpoint.
So, Senator Coburn, the advocate's hat that I was referring to was not a political hat. It was the hat that I wear as Solicitor General of the United States, representing the interests of the United States. That has nothing to do with my own political views. It has to do with a long and historic tradition that the Solicitor General's office has of representing the long-term interests of the United States government.
Well, then let's move back to your political hat. How are you going to take that off?
Senator Coburn, that hat has not been on for many years.
If I wanted to sponsor a bill and it said, Americans, you have to eat 3 vegetables and 3 fruits every day, and I got it through Congress, and it's now the law of the land, you got to do it. Does that violate the Commerce Clause?
Sounds like a dumb law.
Yeah, I got one that's real similar to it I think is equally dumb. I'm not going to mention which it is.
But I think that the question of whether it's a dumb law is different from the question of whether it's constitutional. And I think that courts would be wrong to strike down laws that they think are senseless just because they're senseless.
Well, I guess the question I'm asking you is, do we have the power to tell people what they have to eat every day?
Senator Coburn, I
mean, what is the extent of the Commerce Clause? We have this wide embrace of the Commerce Clause, which these guys who wrote this never, ever fathomed that we would be so stupid to take our liberties away by expanding the Commerce Clause this way. What if I said that if eating 3 fruits and 3 vegetables a day would cut health care costs 20%? Now we're into commerce. And since the government pays 65% of all the health care costs, why isn't that constitutional?
Well, Senator Coburn, I feel as though the principles that I've given you are the principles that the court should apply.
Well, I have a little problem with that. The fact is that we have this expansive clause, and we have to have some limit on it. And if the courts aren't going to limit it within the original intent, instead of continuing to rely on precedent of this vast expansion of it, the only hope is that we have to throw out most of the Congress. But the point is their original intent is that you wouldn't ignore their original intent. And what we find ourselves today on the Commerce Clause is that through a period of precedent-setting decisions, we have allowed the federal government to become something that it was never entitled to become. And with that, a diminishment of the liberties of the people of this country, both financially and in terms of their own liberty.
I would look to Gibbons v. Ogden, where Chief Justice Marshall did, in the first case about these issues, essentially read that clause broadly and provide real deference to legislatures and provide real deference to Congress about the scope of that clause. Not that the clause doesn't have any limits, but that deference should be provided to Congress with respect to matters affecting interstate commerce.
The oath that you'll take as a justice of the Supreme Court is to uphold the Constitution and our statute.
Well, I think I agree with you on that, Senator Coburn.